Jerry's going to start with general filing.
Other than that, I won't have anything to talk about.
Maybe we'll just talk in unison.
Well,
We'll see how that works for you.
Feel free to jump in.
Okay, thanks.
And also feel free to ask questions here. This is really the meat and potatoes of what you're there for. We want to, if you should have questions, feel free. And just as a housekeeping thing, I have you starting on illegal use. But,
oh, that's fine.
That's fine.
And
jump in.
why don't we take a break after Monday?
I'm sure.
Yeah.
Okay. So the first thing is that take a look when you are reviewing the documents in the court file, and be cognizant of the fact that your client may not even always bring their court papers to court. They just know they have to be there, and some of them come without their papers. So you may have to go in to the clerk, ask to see the court file. Most of the clerks don't like you to take the file out of the courtroom. So you may have to just take notes right there and look at the file. Examine the return date, number one, as it relates to the service. Section 733 of the RPAPL dictates that the case must be brought between 5 and 12 days from the date of service, so that if it's earlier or later than that, the petition is jurisdictionally defective and you can get it dismissed. And I think Grace alluded earlier when she was talking to you that getting a case dismissed, however, may not, just because you can, may not be your best resolution of the case. So don't quickly jump onto a situation that may provide a short-term benefit, but a long-term detriment to your client. Take a look. If it's only a technical defect that you may well be able to win on, you may want to use that as a negotiating tool to resolve the entire issue in the long term, rather than simply have forced the petitioner to refile, correct the defect, and now your person is out in a couple weeks after you were successful, but your client is not going to be successful. So take a look at the long-range picture.
I'm just going to interrupt Jerry for a moment.
Absolutely.
We talked a little bit about what order we should have presented this in, and we're doing defenses after negotiation strategies. You should do the analysis of defenses first, because the way in which you approach the landlord or the landlord's attorney is going to be dictated by what you know about the case. What are the defenses I can raise? It's really part of your negotiation strategy. So we're doing this a little bit in reverse, but know your defenses first. And secondly, I agree with Jerry that a dismissal, it's not always assured. Many judges will look at things differently, and it may not be the best outcome. But be sure that what you're getting through negotiation, if the other side is offering you 10 days before the tenant is going to be put out, you know that it's going to be 7 days anyway. So talk to your client. Do we want to agree to this? It gives you 3 days more than you'd normally get. Or is it worth taking the chance that you can get in front of the judge, get it thrown out? It's going to take a while before the landlord refiles. Maybe you'll be back in court in a week to 10 days, but even if your client loses from there, it's still another 7 days out. And that might be huge for your client. It may mean that they're going to get paid, and now they have some money to work with. You may not understand completely your client's situation, but 10 extra days may be the difference between another paycheck, or now it's the first of the month and it's much easier to find a new place on the 1st than it is on the 17th. So have a discussion with your client. Sometimes getting it dismissed is good.
Right, and your clients, oftentimes, I've noticed this many times when I've been the attorney of the morning, and that this court appearance can wreak havoc on their economic life. The court appearance itself. They may have just started a new job. Many times I've had clients in the Attorney of the Morning program who've just started a new job. They had to take this day off. They really need this thing to be resolved now if possible. And don't take that lightly, because if they have to come back to court for any reason and have to take another day off or another morning off, they may well lose their job and they're going to be worse off than they were before. So take the whole picture in when you're determining what strategy you're going to employ. The next one goes back to how your client was served, and again, we touched on that earlier, and this is where that RPAPL 735 service is key, and that is if they were not served properly, then that is a jurisdictional defect, and you can move to dismiss based upon that fact alone. And it can be simply that even though they actually received notice, that the landlord says, yes, but I taped it to the door and I mailed it certified, and the court really is required to, now when I say required, they don't all do that, but they're supposed to look at this as defective service because the person did not mail it regular mail. These are strictly construed proceedings. You have to emphasize that to the court, and if service is improper, it's improper. And quite frankly, the case should be dismissed. The court really has no jurisdiction under which to hear it. And the same kind of service holds true in non-payment cases for the notice to pay or quit. Now, in a notice to pay or quit, that can be oral. It can be an oral demand, or it can be handed to the person, in which case they don't have to follow it up with the 2 additional mailings. However, if they use any method of substituted service for either serving the petition or for serving the pay or quit, then they have to do it properly and they have to follow it up with the 2 mailings. So find that out from your client, check. The court really requires, if it's substituted service on the affidavit of service, that little return receipt requested card be there. If it's not there on the court file, then let that be a red flag and explore that issue in more depth with your client. Check the affidavit of service to make sure that it has been filed with the court within 3 days of the date of service. That's a 735 requirement as well, and it's also a CPLR 306A requirement. So that affidavit of service has to be filed in a timely manner. However, this one, don't base your whole case on, all right? Because this one, the judges, just from my practical experience, are more inclined to correct what they call note pro tunc, as if they will issue an order saying we will deem this properly done if it was maybe missed by a day or so. So don't put all your eggs in that particular basket. Look to see if the notice of petition contained a demand for an answer. 743 the RPAPL sets out that if a demand for an answer is made in the notice of petition, and again, I don't think we've talked about the 2 basic pleadings in a summary proceeding are the notice of petition and the petition. The notice of petition is the equivalent of a summons. The petition is the equivalent of a complaint. So in the notice of petition, if they've demanded an answer and they've served the respondent 8 or more days prior, then the respondent was required to answer either orally or in writing 3 days before the return date of the summary proceeding. So be aware that your client could possibly be precluded from asserting all of these valid defenses that you've ascertained that they have if they didn't properly answer. Now, again, courts, especially in Buffalo City Court, are not very strict. They don't demand very strict compliance with that. However, should you practice in the towns and villages, it's an entirely different story. Check to see whether or not the petitioner himself is and I'm old school, I say himself. Whenever I say himself, I mean him or herself. But check to see if the owner, if the petitioner is in fact the owner or landlord of the real property. Agents, managers, powers of attorney cannot maintain a proceeding in their own name. So if you've got ABC Management Company, and I think and we have to inquire here, does the Attorney in the Morning program have the ability to check? Do they check title when they?
Sometimes.
They do, okay. So if in fact a management company has brought this proceeding as opposed to the owner, you may well be able to have this matter dismissed because the management company is not authorized to bring a petition. It has to be done by the owner or the landlord. There is a distinction between owner and landlord. Grace and I we've been practicing, I've been practicing this for 40 years. She hasn't been practicing that long. But I've been doing this for 40 years, and there's always a fuzzy, everybody says, what's the difference between a landlord and an owner? And there are some distinctions. I think for our purposes here, we really need to concentrate on number one, are they the owner of the property? Or number two, the most common landlord that is not an actual owner is somebody who's a tenant under a lease and they've subleased to somebody else. That gives them the right to be a landlord as well.
It may be that a non-owner who enters into a lease agreement with a tenant, somebody who has authority to enter into a lease agreement, the owner is given that person authority, may be considered an owner, and it's section 721 of the RPAPL that sets forth who a proper party is, who has standing to bring an eviction proceeding, and that's where it says landlords, I think that's where it says landlords and owners. So generally speaking, you know, as the tenant's attorney, you can argue that it needs to be the owner, and if you have questions about whether it's the owner or the owner's brother, you know, your client says, well, I don't know who this person is, or the owner lives in England, you can raise that, and then the burden is on the petitioner to establish that they in fact have standing to bring the proceeding.
Check to see whether or not your client is a subsidized tenant. And if they're a subsidized tenant, check the petition, because the petition, if they're subsidized by Section 8, the petition must reflect that the tenant is a Section 8 tenant and that the landlord has met all of the statutory and regulatory requirements to evict a Section 8 tenant. If it doesn't allege that, that's grounds for dismissal pursuant to a case that I think Grace was that a appellate division case?
Yeah, it's included in your materials. It's Ellicott Community Redevelopment Foundation versus Jeanette Davis. And I think there's also another case, Volunteers of America versus Almont, which also stands for that. But they're in your materials. But there's definitely a Fourth Department case on point.
Also, inquire with your client as to whether or not they are still in possession of the property. You may think that's sort of an absurdity, but oftentimes someone has already left the property and the landlord is using the summary proceeding vehicle to obtain a money judgment for rental arrears. If the tenant has vacated the premises prior to the commencement of the action, then the court is without jurisdiction to render either a warrant or a money judgment. There's a question in the back.
What if the tenant was there when they commenced the proceeding that he has left since then?
Then the court does have jurisdiction. It's only before the commencement, if they're vacated before the commencement of the proceeding, that the court will not have jurisdiction.
And this can be very fact-based. So if the tenant never returned the keys, if the tenant left lots of, garbage behind in a car parked in the driveway, the landlord may not legally have regained possession if there was no knowledge, but if it was a month ago, the tenant moved out, the tenant advised the landlord, the keys were returned, that would be a clear-cut situation.
I actually had a case like that not long ago where the tenant said that I was not in possession of the property when this proceeding was commenced. therefore the clerk had no jurisdiction, has no jurisdiction to render any decision on the case. And in fact, she was not in possession of the property, or she did not live there anymore, but all of her things were still there. And I was able to, I'm right, wrong, or indifferent, I don't know if it was correct or not, Grace would probably disagree, but I was able to convince the judge that they did have, that as a matter of fact, they were in possession, because we were not authorized to go into the apartment to remove any of her possessions without bringing in such a proceeding. We ultimately, I think, placated the judge by saying we're not interested in a money judgment, we simply want the warrant of eviction so that we can remove the tenant's belongings. But I'm not sure that that would go that same way in every instance. In Section 8, well, in subsidized housing cases, you should be aware that if the landlord is proceeding for attorney's fees or late charges only, and not back rent in a non-payment case, that is not maintainable.